Judge Briggs, Hussam Bin Saud.
Ms. Beverley-Smith.
Good morning. I'm appearing this morning with my friend Mr. Carey and Ms. Hartson, my friends Mr. Arden, King's Counsel, Mr. James, King's Counsel, Mr. Glover and Mr. Brown are appearing for the respondents. In terms of the timing, we've had a discussion between ourselves, and I was planning to speak for an hour and a half.
Yeah.
So till midday.
Yes.
My friends would have an hour and 3/4, and I'm proposing to have a quarter of an hour at the end.
That sounds fine with us, I think.
Convenient. As it's a rolled up hearing, I was proposing to deal with the grounds in more detail. Convenient.
Yes.
What I was intending to do was start by providing a brief overview of the case as we see it, and then consider by reference to the 5 proposed grounds of appeal where we say the judge went wrong. And if that's convenient, I'd turn first to section 265 of the Insolvency Act, which is at tab 2 of the authorities bundle, page 3 electronically. And by reference to the wording, you can see it establishes what's required for the bankruptcy jurisdiction to be engaged. And you can see as you work through the section, it starts with the most significant of connections, COMI, and it then proceeds to a series of lesser connections. So you have COMI in the EU, up in Denmark, and an establishment in England and Wales, then domicile, and then 3 possibilities where the condition only needs to be satisfied at a single point in time in the relevant period, and that's if your ordinary resident has had a place of residence or has carried on business in that period. So you can see the scope as widened previously under the Bankruptcy Act 1914. It was only a 1-year period, so it's expanded to 3 years. And as the section was originally enacted, personal presence in the jurisdiction at the time was sufficient. That's now gone. But what you can see from that is Parliament's intention to provide a wide basis for the court to assume jurisdiction. And in so doing, Parliament's determined what is sufficient connection for the purposes of engaging the jurisdiction. And so beyond that, the role of the court is to carry out a factual investigation to see if the tests that Parliament has set out are satisfied. And it's no part of that exercise to skew a factual analysis by considerations of sufficient connection or legislative purpose. In relation to being ordinarily resident...
Well, hang on.
Yes.
I understand your submission that you don't need to skew the analysis by introducing a concept of sufficient connection, which doesn't appear in the statute. But did you say you also have no regard to legislative purpose?
I think in
I thought that's what you do have regard to when you're trying to understand what a place of residence is.
Well, in terms of determining what elements you should consider, I would obviously agree that legislative purpose is relevant, but in terms of the factual inquiry itself, one needs to just simply look at what the facts are rather than interpreting in a particular way. And it's just, that's all I was trying to convey by that.
Okay.
In terms of being ordinarily resident, that requires a factual analysis of historical actual residence to establish whether the requirement is satisfied. And that does involve consideration of the nature of the residence. And the cases concerning that sort of residence are considering the actual act of residing and whether the act of residing is, for example, ordinary or usual for the individual in question. But determining whether a debtor has a place of residence requires an entirely different investigation of our submission. It's looking at availability, a place at which the debtor could reside if he so chose. So it's looking at the existence of a physical property or properties. It's looking at whether that property or those properties were at any point in the relevant period available to the debtor as a place to reside.
So just to be clear, your legal test is, was there a place that was available to the debtor?
Exactly, yes.
And no more. I mean, a hotel is available to a debtor. That won't do.
Well, you have to consider the quality of the place of residence. So in this particular case, I'll come on to that in a moment. In this particular case, you have a very long-standing place of residence, namely your house.
So hang on. A moment ago, the test was there somewhere available?
Yes.
But that's not the whole of the
Well,
test. What is the whole?
there are two elements. Is it available, and is what's available a place of residence? And so in relation to whether it's a place of residence, one's looking at what type of residence you have, and obviously a hotel wouldn't satisfy that sort of test.
So what is a place of residence?
So a place of residence is where someone can reside that has an element of continuity and permanence. I've got cases.
So where someone could reside with a degree of continuity of permanence.
So a place you could go back to, for instance. But what it's not looking at is whether the debtor in the relevant period has actually gone back to it. It's whether he has a place of residence rather than whether he has occupied a place of residence.
So can I just be clear about this? Does it matter whether the debtor has ever been there?
Well, it may not, because if it is for instance, if he's just bought a new house, but hasn't, which is furnished, but he hasn't actually got round to living in the new house, that would still be a place of residence available to him, even though he hasn't resided there.
What about Airbnb? I mean, I dare say you could stay in an Airbnb for an indefinite period. Does the fact that there are lots of Airbnbs in a place mean that a debtor has a place of residence?
In terms of whether that's a place of residence, if the nature of that place of residence is such that it could be seen as his residence, then that might satisfy the test. Because, for instance, it wouldn't really matter if it's an Airbnb or a lease in terms of occupation.
Can I suggest a slightly different way into this? Might be worth thinking about. I mean, there are two different concepts. One is occupation, which is generally what you do with an Airbnb or a hotel or something like that.
Yes.
And then there's the concept of residence. I mean, is there built into the concept of residence something other than mere occupation?
Well, certainly in relation to the Lacatonia case, for instance, the judge there held that mere occupation was not sufficient. It's obviously conceptually difficult to say what's the difference between occupation and residence, but the difference would appear to be by reference to the property in question and the type of relationship the debtor has with the property in question.
You see, I understand your test, although you break it down into two. What you're saying is that the person must have a place available for residence. You broke it down slightly differently. You said, is there the opportunity or the availability of somewhere, and then that somewhere is a place of residence. And I'm just wondering whether really what you're saying is there has to be a place available for residence, whatever residence means. I mean, I'm at the moment, I'm still struggling with your formulation.
Well, in terms of what you are required to look at, it is a physical entity, a place of residence. You then have to decide what would amount to a place of residence.
But it's not simply any place that I might be able to occupy, because that would just be a hotel.
No, exactly.
The Savoy would be
so you have to
place
look
of residence.
I think in terms of a place of residence, you have to see why it is said it is his place of residence.
What do you have? Is the key not so much? I mean, it's obvious it has to be his.
Yeah.
But is the key in the concept of residence? What does residence mean, as opposed to mere occupation?
Well, obviously that word can be used in many different ways. For instance, you talk about students having a student residence, for instance, and essentially it means, I suppose, day-to-day living and enjoying the facilities at the property.
But I would do that if I was staying at the Savoy.
Yes. So in terms of whether there's a difference between occupying and residing, on the face of it, they both cover the same activity, which is staying in the property.
So what determines residence as opposed to staying?
Well, I would say in terms of the distinction you're looking at, it's whether it's a place of residence. So you're looking at the nature of the property as opposed to the nature of the occupation. So whether it's a place of residence or a place of occupation may not make any difference in terms of what actually physically is going on the ground. What's important is that it is his place of residence, so a place where he can reside. And as I say, in terms of residing, there's no suggestion that the particular facets of residing are different in fact from occupying, which obviously involves residing, it might be said.
Then, as my Lord put to you, I mean,
Yes.
there is a whole host of places that are available for occupation by anybody
Yes,
in this country,
of course.
and that can't be what this test means.
And I agree entirely. So that's why you're looking, the test is looking at the place that's available, and whether that place is one, first of all, you can reside at, and secondly, if you can reside at it, whether it's a place that's available to you and with which you have a sufficient connection for it to be your residence. And if you look at what the legislation said before, it referred to a dwelling house.
You had to have the dwelling house.
You had to have a dwelling house. So there's no change in terms of what you had to have. And in fact, Mr. Justice Roth, in the earlier bankruptcy petition, made the point there's no distinction between what was a dwelling house and is now a residence, a place of residence.
Yeah, but you don't have to own it. I think that's clear.
It's clear you don't have to own it. Clear a license is enough.
So, I mean, if, for example, as I can't remember who it was, somebody who's a better historian than me will remember this, but there are stories of people who lived out their latter years in a penthouse apartment at the Savoy or some
Yes.
London hotel.
Yes.
Would that at some point become their place of residence, and if so, why?
Yeah, if so, and why would be by reference to the relationship between the debtor and that place. So if essentially a room in the Savoy had become the equivalent of having a lease of a room in the Savoy, that sort of permanence, then by reference to that relationship, I think you would be concluding it was a place of residence available to the debtor.
So if every time somebody a wealthy individual came to London, they stayed in the same suite at some other London hotel, let's just say, I don't want to give the Savoy too much airtime, but the Ritz or somewhere, but that was where every time they came to London, they were accustomed to stay. Would that at some point, and if so, why, qualify as a place of residence?
Well, you would be looking, I think, as to whether the duration of those stays was such as to produce that result. Because, as your Lordship rightly observes, where you're looking at a hotel, the immediate assumption is it's not a place of residence. That's what you would assume. So it would have to be something about the nature of the occupation for it to become this place of residence. So you're looking at the relationship between the debtor and the property, and that would involve looking at the amount of time spent by the debtor at that property, residing in that location. The difference in our case, of course, is you have properties specifically dedicated to the family.
Just thinking about our case,
Yes.
you say you're right. You don't need to have a legal or equitable interest in a property.
Yes.
There wasn't. And you point out that a license is good enough,
Yes.
and I follow that. But there's no evidence, is there, that during the relevant period, the Prince ever had a license to stay at any of these properties? Or when I say that, when I say no evidence, on the judge's findings, there was no license at any time to stay at any of these properties.
Well, certainly there wasn't a piece of paper that could be seen to be a licence, and certainly whether or not, well, this is, as you says, there was no evidence of any discussion by which the Prince was told, you have a licence to stay there, because obviously families don't operate.
I mean, he never went to any of the properties. If he had wanted to, he could have asked, and then he would have been licensed. But as it was, on the judge's findings, there was never a license to go to any of these properties.
Well, I think in terms of the two different categories of properties, one is York House, and the others are the properties acquired in 2016, 2017. In terms of York House, that was a property at which he resided.
He had resided.
He had resided. He was there as a student.
But there's no basis, is there, for saying that he ever went there during the relevant period, or that he ever had a licence to go there during the relevant period.
Was in terms of interpreting permission as a licence, as opposed to permission being simply a formal way of acknowledging that the property is owned by somebody else, which is really what the evidence is about permission.
On the judge's findings,
right.
he never had permission to go to York House during the relevant period. He could have got it, but he didn't.
During the relevant period, that's entirely right, because of course the relevant period was subject to a couple of very significant restrictions, one of which was the possibility of going to jail if he put his toe in the jurisdiction.
So understandably, he didn't want to come here.
Yes.
But he didn't either have permission to go to any of the other properties during the relevant period, and he never went there.
That's true in the sense he didn't have a formal licence to do so, no.
He could have got permission probably, but he didn't have permission, and he didn't own the property, and he never went there.
In the relevant period.
In the relevant period.
Yeah. But that suggests that you need to have a licence for it to be a property available to you. So if you are looking at it from a point of view of what do you need for it to be your residence, I think what your Lordship is suggesting is that there should be some formal contractual analysis on this, of the position, as opposed to the informal way families operate.
I think I'm suggesting it's very, very difficult to see how you can find that someone has a place of residence. If they don't go there, they don't have a legal or equitable interest in it, and they don't have permission to go there.
Well, you have to look at the historical background in our respectful submission, because what you are looking at is, as I say, availability.
I thought you said that the historical position was relevant to ordinarily resident, and that concept, that when you were looking at place of residence, it was a matter of pure fact.
It's pure fact as to whether or not the place exists, but in not determining whether it is his place of residence, you look at it historically. So in order to say, is this his place of residence, you would be saying, well, is it available to him?
What's the high watermark of the judge's finding on availability? As you put it, I think it's becoming very clear. Your test is available to him.
Yes.
I mean, that's your test. Is there a property which is available to him? I think.
Yes.
In which to reside, which is to occupy in
yes.
a normal way.
Yes.
So what's the judge's finding? What's the judge's best finding as to availability of a property?
Well, he takes the view that there's no expectation, I think he puts it in terms of expectation that the Prince would reside in the property.
So I asked you for your best one.
Well, obviously he recognises the fact that there was occupation, so there was residence in the period whilst he was a student. After that period, he says there's no evidence to show residence. So in terms of the property being physically available, I don't think there's any dispute. It's physically available in the sense that it remains as it did in 1980, owned by his mother, and he asked for permission, he would get permission to be able to stay there. So, I mean, in terms of the position on the ground, then, as I say, it's not in dispute that that's the position. In relation to the other properties acquired in 2016, the evidence was that they were acquired in the names of his wife and his children, and as evidence that if the prince wanted to stay there, he would seek permission. And all these properties are vacant, fully furnished residences. But in terms of findings by the judge that they were available, he didn't approach it in that way. He didn't look at availability. He was looking more at intention. And we say that's really where the judge has gone wrong, because what he's looked at is what were the prince's intentions.
But did you argue, I mean, did you actually put to the judge that the relevant test is availability? If you see, particularly in relation to the New London properties, we were saying it was available to him, and he was saying that there was no, the judge was saying there's no intention. Because of the changes in the, I mean, how the judge analysed it was by reference to changes in the prince's lifestyle. So there was very little evidence between 1990 and 2007. There was some travel records after 2007. But what the prince said was that he'd basically gone back to Saudi Arabia and thereafter lived in Saudi Arabia and wasn't having underneath his papers. And then in the later period, you've got two events that the judge focused on, the first of which was that Prince became the companion to the King of Saudi Arabia and therefore had to be part of the King's entourage and therefore in Saudi Arabia. And then secondly, he was appointed Emir of Al-Bahar, and that required him to be resident permanently in So is this right? You'd say that even if a person has a settled and finite intention, sorry, a settled and indefinite intention never to go to the country, in other words, absolutely under, I will never go again to that country until I die, or indeed even after I die, I just don't want to go there ever again. In theory, there is a place of residence available. If he was to change his mind, that's good enough. He would have to have abandoned the residence. So the cases like Nordenfeld are cases where residence has been abandoned because the house has been stripped of its furniture and put up for sale, for instance. And that was seen by the Court of Appeal as being abandonment. Well, I can understand that if it was a house that the person owned to start with,
yeah,
and was stripped and then put up for sale. But I mean, but assume it's possible to have a place of residence. I think you do say he did have a place of residence prior to 1990 when he was a student. I think you'd say his place, the judge found effectively that was his place of residence up to 1990. He never actually owned it.
No.
It wouldn't have been his call to sell it.
And I think our point is that the nature of the occupation at that stage is no different from the nature of the occupation subsequently, subject to the same restrictions and limitations.
Now, we've taxed you a lot. You'd better develop your grounds.
Yes, thank you. But I think it's important, certainly from our point of view, for the court to understand how we see the test applying. In terms of the ground, the first ground is in relation to the errors the judge made. Just lost my... which, as we identify in our grounds of appeal, is an error of making, first of all, conflating ordinary and usual residence with place of residence. And as a result of that, showing that the debtor had a settled purpose, had to have a settled purpose, which he identified as being for education, business, or professional employment, health, or love of the place. And that's not a requirement identified in any of the cases relating to place of residence. It's entirely derived from cases concerning ordinary or usual residence. Whilst if a debtor acquires a place of residence, so evidently there must have been a reason for doing so, there's no ongoing requirement that that purpose is maintained.
Sorry, I've just lost where you are, sorry.
So I'm looking at paragraph 148(3) of the judgment. I apologise, my computer's decided to made the mistake of thinking I would rely on electronic bundles, and now my computer's misbehaving.
So 148.
And 148(3). So I'll get the. If you look at paragraph 148(3) of the judgment,
Yeah.
you can see the judge says that in relation to ordinary residence, usual residence, place of residence, tool of art used in many statutes.
He says
So it's a tool, sorry, it's a tool used in many statutes, not a term of art.
What does he mean by that?
It would appear that he means that you look at the concept, giving it its ordinary meaning, which is certainly what Mr. Justice Roth said.
So it does have a meaning. So what is the meaning? What is the ordinary meaning of residence? If he says it's not a term of art, it's an ordinary word of the English
I think all he can mean is it's a place where a person resides. It doesn't really answer the question.
What he's put in inverted commas in relation to place of residence is the word residence, not place.
Yes, that's true.
In terms of residence, as opposed to place of residence, was he wrong to think about someone having a settled purpose?
Well, I think the problem is once you start putting inverted commas around the word residence without including words place of, you're looking at something different.
And do you need to have a settled purpose?
Well, that's what he says, as you can see in that paragraph.
Yeah, but do you say he's right or wrong?
We say he's wrong. He's importing into place of residence something that's relevant to ordinary resident or usual resident.
And I follow that point. Can we just break it down? Do you say he would be wrong in that sentence if he was simply looking at residence?
If he's simply looking at residence in the sense of residing, then the cases that deal with residence do require a settled purpose, as he says. Doesn't say that's not our case.
But it could be that that's sort of consistent. You need a place of residence, therefore you need a place at least where you can have such a settled purpose, possibly where someone does have such a settled purpose.
Well, certainly you obviously can have a settled purpose at a place of residence. There's no problem about that. The question is whether it's a requirement for it to be a place of residence.
So you say the debtor doesn't have to have the settled purpose. It's enough that he has available to him a place where, if he chose to spend that time there, he could in fact reside with a settled purpose.
Yes. And you can see that he takes that concept through to his concluding paragraph, so paragraph 235, for instance. He's there looking at the question as to intention. And then similar to 257.
So what in the context of the legislation does the need for a place to be of residence really add? You say he needs to have available to him a place in this jurisdiction.
Yes.
Where someone could reside if they wanted to.
Yes.
Well, that means that the debtor himself doesn't have to have any sort of residence connection at all. I mean, suppose he chose to use as an office somewhere where he could in fact have lived, that would be good enough, would it?
Well, as I say, what Parliament's clearly intending is to have a wide net drawn as to what amounts to jurisdiction. So, for instance, it can at any point in time in a 3-year period. So it's clearly intended to be a wide net.
I think you say it's jurisdictionally wide.
Yes.
But there would be discretion not to exercise it in certain circumstances. I mean,
if the connection wasn't sufficient,
yeah, I mean,
exercising of discretion, you might say this is not an appropriate case in which to make a bankruptcy order.
so if we go back to the sort of the corporate winding up context, which I appreciate is different from bankruptcy, obviously,
Yes.
but there you have a company which is said to be a very wide jurisdictional net,
Yes.
but it's only ever a jurisdiction that will be exercised if there's a sufficient connection, and that's said to be
Exactly,
a question of discretion.
Yes. And
Retracts.
yes, we'd say similarly here in relation to bankruptcy. So the court would have that further question to ask itself.
Yeah.
As to whether to make a bankruptcy order in the circumstances, even though the test was satisfied as to residence. So as to place of residence, I should say.
Is it good enough that someone has available to him a place where someone else resides?
Well, certainly you can have a place where somebody else resides as well. So there's no problem.
Yes, I see.
And I think one of your authorities actually makes that point.
So if I say to somebody abroad, look, anytime you want to come to London, you can stay with me. Is that a place of residence for them?
Well, it might be if that happens on a sufficient basis for it to be viewed as...
Why does it have to happen at all? I thought you said earlier if you bought a new house, that would without more be a place of residence.
Yes, I think you again look at the connection between the debtor and the residence. So if you said whenever you come you can stay, then that could be a place of residence. If on analysis of that relationship it was such that one could see that he is able to treat it as his residence.
So since we keep distracting you, the first error of law by the judge is by requiring the settled purpose.
Yes. The second one is introducing a requirement of sufficient connection to the jurisdiction. And as we've just discussed, that's relevant in relation to the exercise of discretion later. But you can see if you look at paragraph 150 of the judgment, the sufficient connection is used in deciding on the weight to give to any given set of facts. And he's importing into the factual analysis sufficient connection, which we say shouldn't have done.
Now, what do you take that first sentence to mean? So, sufficient connection is relevant when deciding the weight to give to any given set of facts. So,
Well, I take it to mean that in assessing, in carrying out the multifactorial investigation,
You say he's transposed a factor that is relevant to the exercise of discretion, namely, is there a sufficient connection, to the jurisdictional test when assessing facts.
yes,
So, again, going back to the corporate context, you wouldn't say it's relevant to deciding whether something is a company, that it's got a sufficient connection. You just say, no, the question is, as a matter of fact, is it something that English law recognises as a company
yes,
within the meaning of the statute? Because that's the jurisdictional test, and the question of whether it's got a sufficient connection is only relevant to the exercise of discretion.
exactly.
Yeah, and he's what you say is he's mixed up the two.
Yes, because he's importing sufficient connection into the factual analysis, so yes.
when you say the factual analysis, not into finding the primary facts, but in deciding whether the primary facts amount to a place of residence.
Exactly, yes. So, in relation to the evaluation of the facts.
Yes.
And then the third area in terms of principle is whether the debtor could be said to have essentially lost his place of residence in the absence of a finding that the residence had been abandoned.
You say you actually have to make a formal there's a formal requirement of a finding of abandonment that has to be made, is that right?
Well, I think what we're saying is that in order to establish that the place of residence is no longer available to the debtor, you have to establish abandonment as a residence. And essentially in the Nordenfeld case, which is what the judge relies on, paragraph 152, that was a case where the property had been emptied of its furniture and was put up for sale. That all took place before the relevant period started.
But they weren't, we can have a look at it, but I didn't think the Court of Appeal was sort of setting out a test of abandonment. They were just, it was just a narrative, that was just a description of what had happened, wasn't it?
Well, perhaps we should look at it, but essentially what the revert to paper copies. It's actually starting at page 5 and if you look and see what happened, essentially what Lord Isha was seeking to do was to say what wasn't a dwelling house rather than what was a dwelling house. And you can see that he developed that point by reference to abandonment. If a man has a house belonging to him, but he has abandoned it as his dwelling house, that house is not his dwelling house within the meaning of the section. And essentially what the Court of Appeal said was the registrar got it right in saying that the house had in fact been abandoned.
So plainly the Court of Appeal is saying if you've abandoned your house, you don't have a dwelling house anymore.
Yes.
But it isn't, is it, saying that it is a necessary requirement of ceasing to have a dwelling house that you have abandoned?
No, obviously they won't look at it in that way. I mean, essentially, I think what Lord Each was saying was it ceased to be a dwelling house.
Yeah.
Well, it ceased to be his dwelling house.
Um,
I mean, it hadn't ceased to be a house capable of being dwelt in. It just wasn't his dwelling house. He abandoned it as his dwelling house. I mean, that's...
yes, I mean, clearly physical property remained and could obviously be refurnished, but by reference to what he had done, the steps he had taken meant that physically it wasn't his dwelling house any longer. Whilst we're on that page, if you look up the page, you can see a reference to the argument being run by the company, it was a creditor, as to a potential dwelling house. And as to whether or not potentiality would be sufficient. That's in circumstances where the premise is that the debtor had a dwelling house, had it no longer, and the question was potentially the potential of having it in the future. Did that mean that the section was satisfied? And that's addressed by Lord Justice Rigby on page 8. And essentially, he says that he could have adopted a house again as his dwelling house, but that doesn't alter the fact that he had abandoned the dwelling house at the relevant point. So that's what Nordenfeld decides. The other case the judge relied on was...
So just pausing one moment. Leave aside the question of abandonment. He had this house. He could have lived there if he'd wanted to.
Yes.
So why didn't he have a place of residence on your tests?
Because he had acted in such a way that it was no longer habitable as a dwelling house. What the court focuses on is the fact that he's removed all the furniture and put it up for sale.
Actually, I'm not sure he had removed all the furniture, just as a matter of fact. If you look at the top of the previous page.
Yes, so I've perhaps slightly overstated what he did. If you look at Lord Justice Rigby, he says that he had packed it up in such a way that it could not, without some trouble and expenditure, be placed in a position to be used. I think is what he says on the next page.
I mean, it rather looks as though significance was being attached to the intention.
It was attached to the intention to abandon, yes.
But putting it differently, it was not enough. We see at the top of page 6 that the house and furniture were left in the charge of a caretaker, and the debtor instructed a house agent to let it. So the furniture wasn't offered for sale or sold until May 1892. I haven't worked out whether that matters. It doesn't seem to turn on whether furniture was there or not. It seems to turn on the fact that the debtor didn't intend to live there anymore.
Well, I think Lord Justice Rigby does focus on the furniture.
To pick up my Lord's point, it was available to him in the sense that it had just been offered for sale. There was some furniture there. Obviously, it would have taken a change of mind, and some trouble and expenditure.
Yeah.
But there was nothing stopping him going back. You know, he could have just said, "Okay, I don't want to sell it." In fact, if he'd have changed his mind,
which I think is what Lord Justice Rigby recognises in the second sentence of his judgment. He might very easily, after he went away to Paris, have adopted a house again as his dwelling house. So Lord Justice Rigby accepts that.
So mere availability doesn't, to put my Lord's point to you again, mere availability doesn't seem to be the litmus test, because it was available. The question was, what was his intention? It was available to him at all times. If he'd have changed, his mind, he could have gone and lived there.
He could have recreated it as a dwelling house. Essentially, what Lord Justice Rigby seems to be focusing on is the fact that it's, as I say, essentially stripped of furniture is such as to establish abandonment of the house as a dwelling house, as his dwelling house. So the nature of the property has changed as a result of the actions taken by the debtor. And there's no equivalent in our case of the nature of the properties having changed. And as I say, it does recognise that obviously it could become a dwelling house again if it was.
But it could have been his dwelling house again.
His dwelling house.
It always wasn't.
He then adopted it again. So what he's done by his action is to sever the connection between himself and the property as the property being his dwelling house.
Yeah, emphasis on the word his though, because I mean, as I understand it, just looking at the facts, when he went to Paris with his wife and servants, he left the house and furniture with instructions to an agent to let it furnished or unfurnished. So it was perfectly available to anybody who wanted to let it. And indeed, that's what Lord Justice Rigby says. He could very easily have gone back to the house and lived in it again as his dwelling house. So it was always available, at least in the early stages, it was always available to him if it had changed his mind. But the key issue seems to be that what his intention was.
Well, the key issue appears to be the fact of abandonment, doesn't it?
When's the critical year, just out of interest? When does that start?
So
The petition presented November the 9th, 1893.
1893, so November 1982, 1892, should November 1893. He sells the house in December 1892.
So a lot of the furniture had gone probably by then.
Yes, it looks like he started doing it in May.
Yes.
Okay.
As I say, I think what you can see from that is that abandonment is treated as the way in which a house ceases to be its place of dwelling.
And I follow the significance of that point to your submissions. Just thinking about it more generally. You buy a house in this jurisdiction, but you haven't yet moved your furniture in.
Yes.
Do you have a place of residence?
I think it would depend on whether what's in the house is such as to enable you to reside there.
And
So
I'm assuming for this purpose there is no furniture in the house. You haven't moved it in yet. You've got an empty house. So do you yet have a place of residence?
So if the consequence of having nothing in the house is you can't reside there,
Well, you know, I'm quite capable of sleeping on the floor. Take a camp.
well, if you take things into the house, you then are able to make it a place of residence, and therefore, in those circumstances, that would be a place of residence.
But it's available to me from purchase to do precisely that if I want to. Well, after I purchase it, I could perfectly well go in, you know, sleep on the floor, sleep on a camp bed, take a blow-up mattress with me. Why isn't it a place of residence? Is it a place of residence, or if not, why not? I mean,
Well, I think if you look at it that way round, it is a place of residence. And as I said earlier on, it seemed to me if you bought a house, then you have a place of residence available to you.
from day one.
I think in this case, maybe we had a slightly less expansive view as to how you could occupy a property. I think it's gentlemen whose wife and servants maybe were not anticipated to be sleeping on the floor. But I think, yes, nowadays, yours is probably quite right. It would be a place of residence.
I'm very conscious you have limited time and we keep taking you off on
I
points.
obviously want to make sure.
So those are the three areas of law. So then we need to see how you say
Yes,
they impact.
I was going to say there's a further case of
yes.
Kuwait and Newey, which
Yeah.
the judge also relied on in that context. I think that's at page 240 of the bundle. And essentially this involved three properties. And
Can you help me with the page? Sorry, I'm on electronic.
sorry, it starts at page 240 of the bundle.
Not in my authorities bundle, it doesn't. I'm on
It
Latin.
should be tab 13.
And I'm on electronic. Can you help me with
Oh,
it?
you're electronic.
Portrait, I've got it. It's 240. We're a few pages out. Got it? Thank you.
Yes, so.
Right.
With the free properties, and if you turn through to page 95, you see the first of the properties is Queen Anne's Gate. And the judge simply finds there that so if you look at 96(2), since 2014, Miss Newey has been actively attempting to sell the property since at least then, if not before, it's been almost completely unfurnished and empty. And you can see the judge concluded it wasn't in the nature of a residence at paragraph 98.
When he says Miss Newey does not currently live in or reside, what's the difference?
I'm not sure there is one. Oh, if there is one, he doesn't explain what he thinks that difference is. I mean, reside, occupy and live in are all essentially describing the same activity.
Well, I'm not sure I accept that. At the moment, I'm not sure I accept that occupy is the same as reside. Live in, I'm not even sure I'd focused on before.
No.
But I could occupy, I occupy my room at the RCJ on a regular basis. Sad though I am, I don't think I reside there.
Well, that's, I think, yes, I mean, because occupation can be for any purpose, whereas residing involves just staying overnight and carrying out normal domestic activities, doesn't it?
Yes, well that's what I was trying to tease out really.
Yes. I think I would accept that's what really perhaps what the distinction is.
Is not Judge Greenwood attaching importance to intention?
Well, what he says is the property was, I was going to say, if you look at the, he certainly mentions intention, but certainly at paragraph 98, he's not satisfied that the property was in the nature of a residence, so he's looking at the nature of the property.
On the evidence, that was not her relationship with the property. That sounds like an intentional thing.
Well, he's looking at whether it was, I think it was, whether it was her residence, I think is what he seems to be looking at. And what he says is it's not in the nature of residence. That seems to be the conclusion. But I agree, he does refer to intention along the way.
And actually, if you look back to paragraph 62, where he's just dealt with Nordenfeld, he obviously thinks that intention does matter.
But he says that in the context of Nordenfeld, and therefore in the context of abandonment. So what he's saying is the intention to abandon changes the nature of the dwelling, changes its character. He says in paragraph 62. So I was looking at the three properties just to show you what the position was in relation to them. So the second one is Whipple Street, which is dealt with paragraph 90, starts in paragraph 99, and you can see there that the paragraph 103, he deals with place of residence and says he's not satisfied that Mr. Nye occupied or rented it or was successful to her as a residence. So again, that wasn't really dealing with intention. And then finally this Cambridge Gate, which is dealt with from paragraph 104 onwards. And he reaches a conclusion about that, starts in relation to place of residence 110, those conclusions at 115.
I think you would certainly quarrel, wouldn't you, with Judge Greenwood's approach at the beginning of 112.
Yes. I mean, essentially it would appear that in terms of the judge's analysis, there were significant problems of the quality of the evidence that we had in front of him.
But Judge Greenwood seems to think it matters that the property wasn't her settled permanent home, the place to which she returns from business trips elsewhere or abroad. And you say, well, that doesn't really matter, as I understand.
But exactly, yes. Sorry, I didn't got on to the point your lordship was referring to. Yes. So we would say that wasn't an appropriate factor to take into account.
And so, in the end, it isn't her place of residence, according to Judge Greenwood, even though she owned the property and she probably had the right to live in it or to use it as a residence if she wanted to. That's 115.1.
But then for the 115.2, he weighs against that. It was empty, and then there wasn't sufficient by way of evidence to establish what the position was, because of the failure to.
But in 3, he says, the property was no doubt hers, so in other words, she owned it. It was residential rather than not, but nonetheless stood empty and unused. She planned to give it to her daughter, and etc. And then it says, but it was not, on any rate in the evidence in these proceedings, a place in which she had ever resided or lived, even occasionally, or treated as one such place amongst others. I mean, he must have been treated by her, presumably. So he seems to, again, even though you've got a perfectly good residential property which she owned, it stood empty and unused, and it seems to be relevant to him that she didn't either actually go there or indeed treat it as a place to reside or live. So he does seem to sort of say intention is relevant. I mean, if your test is right, he would have had to go the other way on that, wouldn't he? Because if your test was right, this is a property in which she owned and could certainly have, had she chosen to do so, taken up residence, taken up occupation, lived in.
But what he appears to be focusing on is the nature of the property and the condition of the property as being relevant. But I would agree with your lordship, he does appear to be taking into account intention as well, and to the extent he does so, we would respectfully submit that that wasn't something he should have done. So that's what we say in terms of round one.
It would save only, those are the areas of law. What impact did they have?
Well, the impact they had was what the judge finds is that the Prince had no intention of a place of residence in Wales, and that's the key. If you look at paragraph 235 of the judgment, that's the key feature that precludes the property being his place of residence after 1990.
I mean, that's only one of the features he mentions.
No, I accept that, but in terms of the period, he didn't even appear from 1990 to 2000, you see from the previous page, and he forms a conclusion that in the whole of the period after 1990 there was no intention of a place of residence.
I mean, in the same section, he said, didn't visit much, didn't know of the council tax registration. I mean, also, of course, this is not ultimately our relevant period. So what do we find in his conclusions in relation to the key years that we can see would have been different if the judge hadn't made?
Well, if you look at paragraph 258, which is essentially the concluding paragraph, I mean, essentially what he does is look at all the periods, and in fact, in relation to the relevant period, he says almost next to nothing. But 258, you can see him expressly looking at intentions and the purposes of the visit.
And just taking it a stage further, suppose that we were satisfied that the judge had made one or more errors of law and persuaded that they could have made a difference to his conclusion. Do we then send it back to him to reassess it in the light of a correct understanding of the law? Do you have a retrial, or what happens?
And those are all possibilities. We would say that if our test is right, then this court could conclude properties were available, and therefore that there was a place of residence and therefore a residence test is satisfied. Obviously there are other considerations in relation to the bankruptcy, but in relation to that element you would make a finding that our argument's correct and all the facts as found by the judge.
So we would be concluding, would we, that the only reasonable conclusion was that the Prince had a place of residence, notwithstanding that he had no interest in any property here, didn't come to any of the relevant properties during the relevant period, had no right to enter any of the properties, had very good reason not to come to this jurisdiction, had no intention of coming to this jurisdiction. I mean, that's a very big ask, isn't it?
Well, you'd have to balance against that the fact that the relevant property, in particular your house, I say relevant property, in particular your house, was a property that was expressly bought for the purposes of enabling the family to have a residence in London, and that remained available to him. And there's nothing in the evidence to show that he abandoned that ability.
You said it was bought for the purposes of giving, well, I didn't get it quite down quickly enough, but giving the family a residence.
Back in 1979, yes. So and mother and son.
So where's the evidence? Where's the finding that you place reliance on for that?
I think it's in the section dealing with. Well, certainly there was evidence about it. If you look at the section dealing with. Well, I think he starts in 1982, in fact. I'm not sure he does it there.
Do we get that from his mother's evidence, perhaps?
181.
Yes, we might.
Actually, 72 is his mother.
Yes, motivated she wanted to have a family home for her and her son. That was the passage in particular, yes.
Yes. I mean, she does add when he was young.
Yes, so I think he was a teenager at the time. Yes, the Malone friend very helpfully points out paragraph 178 also deals with the position.
Yeah.
And sorry, there's also paragraph 75, did it pick up on that, which is she wanted the property to be available for her and her family. So that's the starting point in relation to your house. And so, to answer your lordship, that's the reason why, despite the fact as your lordship's identified, you can say it's appropriately available to the principal. In relation to the other grounds, I'm conscious of the time. They briefly with those. Ground 2 essentially deals again with the question of intention.
Yes.
And we've looked at the cases. There's a reference to Ralph as well, which is at tab 7 at page 60. And the relevant decision is in Lord Justice Goff, starting at page 335.
Sorry, I just couldn't hear you. Sorry.
I apologise. We're looking at Crouch, which starts at page 60.
Yep.
And various grounds were put forward, but in relation to the dwelling house, that's dealt with at page 334, letter F. And you can see there's a question about the nature of dwelling house. And if you look over at D on 335, you can see that he took the view that there simply wasn't enough material to form a view as to whether or not it was his dwelling house. Along the way, he considered a proposition from Mr. McComb, as he then was, at letter B. This is something that the judge focused on. And this is essentially the premise for saying there doesn't need to be any actual occupation during the relevant period.
I mean, just looking at this, if we look back at 334, we see that the debtor had a lease of 51 Connaught Street. That's at letter G. And 335 D to E, we see that while he wasn't in fact in residence there, he had installed the mother of his son there, and it appears from the evidence that he did at least go to see her there and may well have stayed nights.
Yes.
Although whether he ought to be regarded as a guest or she is his might be a somewhat difficult question. So you have a case where the debtor has a property, he's installed someone there, he stays there, possibly with permission or possibly because he could go there anyway, and yet he doesn't have a dwelling house.
Well, I think the conclusion is we don't know enough about it to form a conclusion.
Well, at any rate, those facts were not such as to lead inexorably to the conclusion that he did have a dwelling house, and it rather looks as though his intention mattered, because if it had been established that he happened to be away with intent to return, that might have made a difference.
Well, I think the intent to return was dealing with a slightly different point. That was whether or not you needed to be residing during the relevant period. So I think that's what that's directed towards, rather than towards the question as to whether or not.
But does that even, on your case, that doesn't even really come into it, does it? You don't have to have resided at all.
No.
That doesn't seem to be Lord Justice Gough's approach.
Well, what he's dealing with there is a situation where there hasn't been abandonment. You can see he's considering it's in the context of abandonment because the reference to Northern Felt immediately follows. And what he's saying is that if there hasn't been abandonment, and that's why it's relevant that the debtor's coming back again, then the test is still satisfied, is what he said.
Yeah.
So that was that decision which the judge relied on in relation to intention. And we've looked at portrait, and you've also seen what Judge Greenwood said about the same issue, but again by reference to the first. And that again is something that the judge relied on. Essentially what the judge was doing was trumping the fact that the judge had an available place of residence with consideration of the fact whether he had a continuing intention to have a place of residence. I'm very conscious of the time. In our written submissions, we've identified at paragraphs 38 to 40 various errors. We say the judge made his factual evaluation of the evidence. And in particular, the absence of records prior to 2007, which he equated as being an absence of visits. And the failure to take account of the fact that, as Judge Barber had observed, there was one stopover in 2010 where, plainly, inconveniently for the debtor, he went to York House rather than going to a hotel, even though it was a short stopover, which Judge Barber thought was a sign that he had a continuing affection for York House. Those base points were not relied on by the judge, but obviously we accept that it's difficult for the Court of Appeal to be too heavily involved in factual analysis. Ground 3 deals with seeking permission and control, and the position here simply is that the debtor explained about permission and how it was essentially a cultural custom, and we cited the various passages about that at paragraph 43 of our submissions. And what those passages show is that seeking permission was not in any way a fetter of the principal's ability to reside at either York House or the new properties, and therefore wasn't something the judge should have taken into account in weighing up whether or not it was a place of residence. And similarly with control, he never had control of the property, and yet that didn't preclude him having accepted to have residence whilst he was a place of residence whilst he was a student, and therefore control not having been a factor at the beginning shouldn't therefore have been a factor at a later stage. And in that context, Mr. Justice Rolfe, at paragraph 37 of his judgment, said that de facto control wasn't a necessary condition and hadn't featured in the list of potentially relevant factors set out by the Chief Registrar in the Khan case or indeed the Black Flynn. So we say again it's not a fact that the judge should give any weight to. Ground 4 is dealing with the conclusions the judge reached about the new properties and whether they were available to the debtor as a place of residence. Again, there's a problem for the Court of Appeal to delve into the facts. I think we'd simply say, by way of a headline point, that the judge failed to have any recognition of the close family relationship between husband and wife and between father and children, which is obviously very apparent in this case. And the places of residence were bought so the family would be able to be together in London, were inherently likely to be available for the whole of the family. and its exclusion of the debtor from purchase was immediately understandable because at that stage the arbitration award had been made, and self-evidently he would have been very welcome if he had wanted to stay in any of the properties.
But if you're wrong on availability, ground 4 is irrelevant.
Yeah,
I mean, ground 4 depends on you being right on availability and then saying that this other pool of properties was available, doesn't it?
yes, exactly. Your Lordship's entirely right. If availability doesn't solve the problem, and you have to have more than that, then I agree, in relation to new properties, we don't really get very far. And then finally, in the minute and a half left, in relation to council tax, that's something that had been very large in the earlier judgments. And obviously, at that stage, there was conflicting evidence about why the Prince had been registered for council tax. What the judge obviously had the benefit of was seeing Mr. Handra, seeing the Prince, and taking a view as to what had happened. I think the only points we would make is that in relation to council tax, Mr. Handra accepted that the purpose of recalling the debtor for council tax was to be able to show it to somebody else, and that in doing so he would have been representing that the Prince was resident at York House. And obviously, to the extent that's a relevant fact, there's not one the judge took into account and he should have done.
Yeah.
So I think
You've done very well, Mr. Overly Smith, notwithstanding all the judicial interruption.
exactly 12 dogs.
Mr. Arden?
It is me, Lord, yes. Well, can I just indicate just the way I'm going to proceed, at least until I get to the sort of evidence grounds. There's a short point on availability and what the judge found. That's really just paragraphs reference. I just want to get it out of the way in case I forget it. Lord, reversing it slightly, I just want to deal quite quickly with the sufficient connection point and whether the judge superimposed a test. And then I'll spend longer on the question of the proper test, and then probably deal quite quickly with the subsequent grounds, because the proper test includes the relevance of intent, which is essentially ground 2. So ground 1 and ground 2 I will focus on, deal more briefly with grounds 3 to 5. The very short point on evidence, while I've got it in mind, is the judge that did make findings on availability, and those are paragraphs 204 of the judgment. Sorry, I'll give the proper bundle reference. That's bundle reference, page 120. And this is recording the available Malone and Friends test. So you can see it being dealt with over at 121, still in the same paragraph. And then he cites, so the pool of residents, he records the argument, and then the available pool of residents' argument is contradicted by the evidence of Princess Sarah, which I accept. And then he records Princess Nora's intention. This is in relation to the New London properties. That essentially it was for that those purchases were for Princess Sarah and the grandchildren. And then Princess Sarah's blunt, this is at 205, not open house. And then you'll...
The New London property, does not include York House.
No, that's right. Those are the 2017 acquisitions. And then at 206, he goes on, even if I accept they're available to the family, the other members of the family, it doesn't follow that they represent a place of residence for Prince Hussam. And then 252, then, it's page page 130, bundle reference 130 in the core bundle. you'll see it's a short paragraph, and it's the third last sentence of the paragraph. To be fair, actually looking at that again, I think this is more to do with even if they were, it doesn't satisfy the test as he's found to be. So it probably doesn't get me quite as far as I had initially thought.
I mean, the judge has dealt earlier on with permission and made findings as to that. Mr. Mobley-Smith obviously says, well, I think he said, I don't think he quarrels with what the judge finds in relation to permission, but he says that doesn't mean that properties weren't available. But at any rate, as to permission, you have got findings that permission was needed.
Needed, and more than a formality. Those are the references. Malone and Friend's case was that it was just a matter of courtesy. You asked, you would always get, and that, one shouldn't attach any weight to the requirement if there was one. The evidence given by the Prince and his witnesses is no, you've completely misunderstood the importance of the ownership of property in our culture, and the strict requirement for a permission to be sought and given. And simply because it's a family relationship makes, particularly mother and son, it makes no difference to that. It's not a matter of courtesy. It's a real requirement.
Sorry, and the paragraph you rely upon for that is?
It's another ground, but.
This is the section beginning at 191.
Yes, I think it's 194.
Which is responding to what's the point made in 193.
So that was Malone and Friend's submission, was that is what the judge should find. It's a perfunctory or politeness. I'm sorry. The passage I wanted was, just give me a moment. I'm sorry, it's 192. It is in the same. And you'll see there it's the reference to the Quran in 192, and then the evidence given by Prince Hussam. What the judge does is to accept. He takes the requirement to be a real one, but accepts and does take into account what he describes as the quality of the permission, which I think is a reference to his accepting that in that case, although permission need not necessarily be granted, as a matter of fact, on the very few occasions that he was concerned with, because the visits to York House are very small, permission would be sought, but was likely to be given.
But you could have a place. Could you have a place of residence if, although you had to ask, it was permission was routinely given and you took it up? I mean, because it's accepted that if you have a formal license, which is, if you like, is a formal permission to occupy, not necessarily to the exclusion of others, that would be a lease, but if you have a formal license to occupy, even if it's terminable, that could constitute a place of residence. The fact you have to ask, or the fact you have to get a consent, however informal or formal, doesn't mean that you can't have a place of residence.
It's what you don't have is you plainly don't have a right, contractual or proprietary, if permission is required.
Yeah.
And so your ability or the availability of the place to you, or your ability to take advantage of it, is it's not even precarious. It's conditional, contingent on the permission being given until obviously the permission is given.
But the mere fact you have to ask doesn't stop it being a place of residence. I mean, if you know, every time I come to London I want to stay in my favourite suite at the Savoy, I have to ask them. But if every time they said, yes, step this way, your favourite suite is available, and I do that on a regular basis, that could be a place of residence, couldn't it? The fact I have to ask each time doesn't mean it couldn't be a place of residence if I spend 5 days a week.
Well, I think I probably will. I think I'm going to quibble with your lordship.
That's your job.
Well, it is. If you ask, when the person is not there, you say, well, take the Savoy or any other hotel, and you regularly go there when you're in London, and is it when you're not in London, a place of residence available to you? It's available. It's certainly somewhere which may be available to you.
Well, you see, what I'm trying to do is, I understand you say availability isn't a test, but I'm just trying to test whether you are actually saying that the mere fact you have to ask means that it can't be a place of residence. I'm putting to you the sort of what I'm not sure whether you're making a submission quite that bluntly. Because are you saying the mere fact that you have to ask for permission to stay means it cannot be a place of residence, even if you routinely get it and do in fact take it up?
Well, Lord, I think Lord, the blunt response is yes, I am saying it can't be because of the requirement for permission. A slightly more nuanced approach would be to say it could be, but the fact that you have to ask for permission is one of a number of factors you take into account when you are, and an important one to take into account, when you are asking, having regard to all the circumstances, a place. Yes, no, I'm sorry. That nuanced approach it works with my test and not the availability test. I think. Sorry,
I suspect this goes off in another direction, but there is a distinction because in the sort of scenario that my lord is putting to you, you will in fact have had successive licenses during the relevant period. Maybe when you have successive licenses, even when you're not in London, you might still be said to have a residence. I don't know, a place of residence. It's a step further to say that in circumstances when you never had a license at all during the relevant period, the fact that you could have got a license if you'd asked for it means you have a place of residence.
Yes, I think that the difference between well, I do see. I understand the point, and I also understand that my sort of blunt response is probably oversimplifies the question. That there may be that to say that there are no circumstances in which I think there are difficulties with hotels, but perhaps with other premises. To say that there are no circumstances that permission prevents those being described as somewhere in all circumstances, prevents those from being somewhere that's available to you. To say, well, no, that can't be the case ever, is probably pushing it.
Yeah, but I'm assuming you don't agree with Mr. Mobley-Smith's availability test. So let's just park that for a second.
Yeah.
Right. That's not the test for this purpose. You say one thing that would, I think you said to me a few moments ago, that one thing that would necessarily mean that somebody did not have a place of residence is that they had to ask for permission to stay there.
Mm.
And that's quite a broad assertion that would, I suspect, give rise to quite a lot of people living here, but saying that they didn't have a place of residence because they had to ask somebody who routinely gave them permission. And if that were right, I suspect the bankruptcy jurisdiction is a lot narrower than perhaps legislators might have intended it to be.
I wouldn't say that, my Lord, in relation to a different test. Your Lordship knows we don't accept the availability test. We say that's far too narrow and contrary to the authorities. The test,
wide.
Far too broad, far too permissive.
Far too broad, yes. And that's not what the authorities make it clear. The Malone Friends test, which we described in closing and describe in the skeleton we prepared for today, we describe as a simple test if it's available, and the place can. And it's a sort of simple test based on the availability of bricks and mortar, possibly with some furniture in it. Now, Lady my Lord, I'll come to the proper test in a moment, but the proper test is a much more multifaceted, multifactorial test. There are many more factors than availability in bricks and mortar that go into that are relevant to this test. I
sense you're cooling on your blunt response.
Retreating.
That consent is a killer.
I'm cooling slightly and moving to slightly more comfortable area, I think is how I would describe this, where I don't have to give a blunt response to that question. If I can move on, I was going to just deal with the sufficient connection test, and I think it might be helpful just to explain how that arose. It actually arose from a point of a construction point. And that point, which we made, and that point was derived from Mrs. Justice Bacon's judgment in Lacotamia. It may be helpful if we just go there now. That's Authorities Bundle 231. And the only thing to note here, this is a debtor's petition under section 263I1 and 2 of the 1986 Act. That's a new edition. The grounds of residence are, so far as relevant, the grounds of jurisdiction are so far as relevant, the same, and the ground relied upon by the debtor in this case was place of residence. On any footing, the time spent and the connection of the debtor was tiny, and unsurprisingly, the judge found that the test hadn't been made out. But the case is important for this court's purposes for a number of reasons. The first one is this question of construction. And what the judge did sorry, I'm just trying to pick up the right part of the judgment.
29 probably is where she starts.
Yes, that's exactly it. It's where, in fact, it's 28, from thirdly onwards. The construction diminishes the test to complete triviality in terms of jurisdictional connection, that is, in a way which makes no sense of the context of the statutory provisions. And then she records and agrees with submissions made to her, and essentially she reads down the jurisdictional grounds. You start with Comey, and then you move down through the various different grounds. Comey, I think either she or Mr. Phillips perhaps described as the gold test, or the gold standard, sorry. And then she observes at 29 correctly that all the ones that go before place of residence connote a degree of substantiality and continuity of connection with the jurisdiction. By contrast, on Mr. Underwood's test, a debtor could invoke the jurisdiction in insolvency court simply on the basis they had permission to occupy the residence of a third party for some period of time during the 3 years preceding the application, no matter how fleeting and transient that occupation is. That would be an absurd result. So what she's doing, she's construing the statute, and then...
this was in the context for a bloke who stayed on his sofas when he was not in prison.
Yeah, absolutely. As I sort of opened with this...
So broadly. I mean, that's broadly what this case was actually all about, isn't it?
That's right. But the point she makes about construction and the conclusion they're worth bearing in mind in every place of residence, case. That was a particularly stark example of a case where if there were a place of residence, it would be to employ the place of residence test in a way which made a nonsense of everything, the nature of the connection that was envisaged by every jurisdictional test which went before it, including ordinary residence, which appears in the same sub-paragraph.
Mr. Underwood's submission isn't that different from Mr. Mobley-Smith's.
Well, quite.
I think Mr. Mobley-Smith would say, well, you don't even need permission, it's enough that you could get permission. Of course, here, none of the properties was in fact the residence of a third party necessarily. Nobody was living there.
But that doesn't necessarily, that's true, but that doesn't detract from the point. It could be the residence could be a room in someone else's flat, and then one could just read this. One could read this passage as applicable to that situation. So that's the starting. I will come back to Lacotomia for the test as well, but so far as the construction of the statute is concerned, that, if you like, was the inspiration for a similar point that we made at the trial of this matter, and saying that when you approach the relevant ground here, it's important to bear in mind that the purpose of this is to establish the purpose of the test, or what underlies all of the jurisdictional grounds, the purpose is to establish that there is a sufficient connection between the debtor, between the debtor and this jurisdiction, or a place within the jurisdiction. The test of so that's sufficient connection used in that sense. Quite independently, quite separately from that, the question of discretion also arose in this case and was dealt with completely separately in the submissions. And essentially, I mean, the court's not concerned with this, but essentially the submission being made was what Dicey refers to as the core requirements, which include sufficient connection of the Drax type. You've got jurisdiction, but as a matter of discretion, you shouldn't exercise it because of the absence of a sufficient connection, benefit, and so on. That was dealt with completely separately. Now, what the judge, where you look at the offending paragraph, this is just the judge, it's as we record in the skeleton for this court. What we've said there is essentially that this is the judge recognising that it's the judge recognising this. It's not really a point of construction. It's an approach that, in the way in which he approaches this case, he should be mindful of the fact that the purpose of these requirements is to establish a sufficient connection of the type that I first dealt with in the course of these submissions. Now, what's interesting...
so you say 150 doesn't really mean what it says. It just... You're saying it's appropriate to, when you're asking what is the test, of place of residence,
yes,
to recognise that it should be one that gives rise to a sufficient connection.
Exactly.
But not to allow it. I mean, it does seem, at least on the face of the first sentence, paragraph 150, to allow it to drift into the fact find, and that would be wrong if he had.
That would be wrong if you say it's got sufficient. It's these grounds plus sufficient connection, or if you read in, certainly if one read that in as an additional or separate requirement, effectively, then that would be wrong. But if one looks at the way that he subsequently approaches the evidence, in my submission, he does it in the right way. And one can perhaps put it, but there's a slightly different way of putting it. It's the same point, I think, that when you're undertaking an exercise of sort of fact-finding, multifactorial fact-finding evidence that judges are required to do in these cases, it may be appropriate at some point to step back and say, well, where am I going? If I find that there is or is not, or there is jurisdiction, what is the connection? It's just really it's a cross-check, if you like.
I mean, the trouble is that if you just say it's all a question of fact, whether there's a place of residence, it doesn't actually help the judge, any judge, because it's not really identifying the test. And the problem is if you just say it's all a question of fact.
Well, that's really the big point, I think, which is the next one I should deal with. The way we approach this on the basis that the simple test, my own friend's simple test, sort of emerged and sort of became apparent particularly over the course of the trial, and now it is his only test. And in closing, we said, no, this is wrong. If you were right, why have we been arguing about all these other factors? What does it matter? What does council tax matter? What does length of stay matter? It's all dealt with by your test. And our approach to the proper test was to do we started with Mrs. Justice Bacon's approach in Lacotamia. And that is where she draws upon concepts of residence from other contexts. And she says, well, when you're looking at something which is called a place of residence, and indeed when you're looking at ordinary residence, or particularly place of residence, you're using a word, residence. Residence has a meaning. It is always going to be a multifactorial approach, but it has a meaning. It's not just, it's a plain word, it's plain language, which has been considered on any number of occasions in any number of other contexts. And it is legitimate when you're asking whether something is a place of residence to ask what it means to say that somebody is residing in that place. And so I can, when one, if you're still in Lacademia, just to remember, it's tab 12 for paper copies, but in either case, page 237. Paragraph 30, between paragraph 31 to 37, Mrs. Justice Bacon considers the natural meaning of residence in other contexts, starting classically with Levine. Now, Levine is a case of both residence and ordinary residence. It's a tax case. And the reference to Viscount Cave's definition there is simply to residence. That dwell permanently for a considerable time, to have one's settled or usual abode, to live at, in or at a particular place. So that's the starting point for what is meant by residence. She then refers to Dubai Bank.
It's actually the word reside.
Yes, sorry, that is, I'm so sorry, sorry.
I mean, reside is perhaps slightly different. If you attach it to a person, you ask, where does a person reside? Is a slightly different thing from asking, is that a residence?
That's right. Well, sorry, that's plainly right. At this point, what the judge is doing, Justice Bacon, is just she's looking at the notion of reside and saying that should inform the approach to what is meant by place of residence, or to residence in place of residence. Can you say of that place? Can you say of that place for the debtor that is a place where that can properly be described as his place of residence? So it gives effect to the concept of reside.
So just pausing there. Are you saying, was Mrs. Justice Bacon saying, that to satisfy the statutory test, it has to be a place where the debtor actually resides? I'm not sure the authorities go that far.
These authorities do. The authorities do not. But what this authority and other authorities do is to stress it's the that if reside is that where you're dealing with residence by reference to like a place of residence, the concept of what it means to reside there is an important one. So you have to be able to, I mean, if you like, if the debtor were there, you could say of the quality of, you could say of that. If the debtor is there, the debtor can be said to be residing there.
Because, but she puts it quite high at 36 when she completes this process by saying, in determining whether the debtor has had a place of residence, it is relevant to ask whether the place was for the debtor a settled or usual place of abode or home. Yeah. I mean, that's really quite a high test, isn't it, for place of residence? I mean, is that very different from, frankly, ordinarily resident? What's the difference between that and ordinarily resident, which she said earlier on is different?
Ordinarily resident,
because, you know, that would, for example, if you have somebody who has their main home usual place of abode in one country, but does spend a considerable amount of time in a house which they own in another, it would sort of rule out the other, wouldn't it? If you took it too literally.
I mean, you can have two homes and two places of abode. I think that's the answer I see your Lordship's concern, but I think the answer to that is you can have two homes. And then, for example, the Lord Chancellor in Levine envisages, I think it's Levine, envisages the Member of Parliament who has a flat in London and somewhere in the country and goes on a regular basis, London in the week, country in the weekend. Both places, he would be said to reside in both places.
Just thinking round it, without thinking about the authorities for a moment, under the old law it was you had to have a dwelling house. It didn't say you had to dwell in it. You didn't have to reside in it. So why should it now be the case that you have to reside in this hypothetical place?
Well, I think if one looks at cases like, for example, if you look at Broche and just look at the way we put it at trial was we looked at these sorts of authorities, and then posed the question, and bearing in mind that Justice Bacon was treating this as being a factor, and that's the way in which Mr. Justice Roth approached it, and dealt with it in an earlier sort of judgment in these proceedings. If one looked at a case like Broche, then you can see that that there is the question that I pose for myself, or for our submissions, is there any inconsistency between this and the bankruptcy authorities, particularly Broche? And the submission was no, because if you look at the nature of the inquiry that Lord Justice Gough envisaged was necessary to make in order to decide whether a dwelling house whether somewhere could be properly described as a dwelling house for the debtor, you see a very similar inquiry to that which what takes place if you're asking whether somebody resides in a country. And so classically in Levine, the Lord Chancellor draws the distinction. He like Lord Justice Gough in Broche, considers, well, what if you go to somewhere for a holiday? Should you treat that as somebody as residing in the place where you go to for a holiday? And the answer is no. So you look at the purpose of the stay, how long it is, whether it's regular, irregular, and so on. So that's residing. And you see the same sort of approach being adopted in Broche, although Lord Justice Gough didn't contemplate both, although the person from abroad, as it were, who comes here, or the person who stays at a place here for a holiday, doesn't deal with that separately. What he also envisages, he envisages the converse, where you reside here, you have a place of residence, dwelling house, here, and you go away, you go abroad. Does that mean that you no longer have a dwelling house here? The answer is no, because you're then looking at the purpose for the absence. But the converse would apply.
I mean, if you, to take your example, or my lords, a little bit slightly differently, you postulated the Member of Parliament with a country house for weekends and a London flat. Let's say that somebody has a, quote, holiday home in Norfolk, to which they go on a regular basis for holidays, not just at weekends, but sometimes during the summer, etc., etc. Is that a place of residence in Norfolk?
I think the answer is it can be, because if you own a second home, there's ownership first of all. There's permanence because you own it, and there will be regularity. There will be a regularity about your visits there, and there will be usually probably a single either a single purpose or a single set of purposes. So when you're looking at all the elements that go to residence, the sort of continuity and so on, settled, so on, you have those. But a slightly different, it would be slightly different if one had a second home and you said to it, as would be quite common, you say to the members of your family that you're still speaking to, I have this place. You can come any time you like. Just give me a call and I'll send the keys. They wouldn't. Why? Because, and even if they did it every year, there's probably a regularity of, there's some regularity in purpose, some regularity in at the times that you go there, but nevertheless you probably say, well, having to ask for permission makes a difference, even despite the open nature of the invitation, and also the absence of ownership, the fact that it's which is connected with permission, your sort of right to go there could be described as precarious.
I mean, I'm not sure this fits with Nordenfeld actually, but thinking to what Parliament might have meant, at least under the old law, Parliament saying, look, it's good enough if you're ordinarily resident here, that's a real connection, or it's good enough if you have somewhere you could live here, surely. I mean, that's a dwelling house. And that doesn't seem to import a condition that you should in fact live here.
No, I think the way
Nordenfeld,
Brosh, I think Brosh, if one looks at Brosh, that I think is consistent. It may be necessary. You need to look at. They don't treat it as an absolute. Well, it's more to. They don't deal with time spent at the property. They don't deal with it on an absolute basis. I think they say the less time you spend there, the harder it will be, or harder it may be to establish that someone has a place of residence. Equally, the longer you stay there, the more likely.
So on that basis, you'd say that somebody who is ordinarily resident abroad, because that's where they have a big house, but I'm going to give you two postulates. Let me just think through the first one first. But who has bought a London apartment, which is theirs, but they've never used it, but it's there. It's theirs. It's empty. They could, if they chose, to get on a plane and come live in it. Mm. Is that a place of residence? They've never used it.
No.
But it is something that it is certainly available to them to use, and they own it. You'd say no, but that's because they've never actually used it.
That's right, because you can't describe that as it's. You're looking at the. Again, I'm sorry. One sort of there's different ways. If one's asking again, it's another way, but if you are asking for. If it's relevant to ask, what is the nature and quality of that person's relationship or occupation of the property? If there is none, then there's no place of residence.
Although they have, in the ownership sense, something which could be described as a residence.
Yeah, and that's Norden, and that's why that's the right way of approaching Nordenfeld, and indeed portrait the properties in portrait as well. In both of those cases, and Judge Greenwood was entirely right in his analysis of Nordenfeld. In both cases. There is property available, but in neither case can you describe the relationship, the relationship between the relevant person and the property. In both cases, is not one which you can. It's not one you can describe as being a relationship that, where the debtor in both cases treats the place as a place of residence. So I haven't put that very well, but
so that was a person who owns something but never goes there. So I'm going to flip it and say the person who doesn't own a property but does frequently live in a property with the consent of the family member that owns it. Can that be a place of residence?
if you, in principle, there's no it could be, but you always have to have regard to any other factor which has a bearing on that occupation. Is it the same reason each time, or is it for random reasons, for example? How frequent are the visits? Are they regular? And so on and so forth. If one took, for example, if one took the stopover point for the moment, say that the only evidence of use was this was just a place that I could use for a stopover, quick shower and so on in between flights. You could see there's use there. It could even be regular. It's certainly short term, but it doesn't have the degree of substantiality, we would say, to satisfy, to turn that place into what is for that person a place of residence.
So if they, okay, so you say you've got to look at, as Judge Greenwood did, at the character, the nature and character of the occupation, for want of a better expression.
Exactly.
Yeah. So it's at least conceptually possible for somebody who stops overnight in a place, every week, every Sunday night, that's where they will be, because that's their accustomed habit. They use a friend's apartment on Sunday night, every night, ready for work on Monday to stay. At least there's no bar to that being a place of residence. It might depend on other factors, but at least that is conceptually possible. It's
possible, but I would suggest unlikely, because it's a bit like stopovers. If you look at if one looks at the nature of the occupation, it's very small. But say conceptually possible, but the argument.
Says, I'll pick up my mail every week when I pass through.
It's the same problem. I mean, it's the same. The staying every night is one that makes it conceptual, because you've stayed. That you can see there's sort of a possibility. Picking up mail, you're not doing anything which could be described as residing. That place is not for your place of residence. It's simply a mail drop.
Okay.
So broadly on this thesis, Parliament has said it's good enough if there's ordinary residence. You don't need ordinary residence if you reside and have a place where you do it.
But residence is usually treated as being ordinary residence. There is the difference between ordinary residence and residence, if one's asking about where someone resides, is it's an awkward one. In sense when you're trying to work out what the differences are. In the Relfo case, which is in your bundles, at first instance, the deputy judge said, well, I can't really see what the difference is. It may only be that it it stresses the need for permanence and continuity. The Court of Appeal nevertheless recognised that there was a difference, but when you look at what they did, it's quite hard to see what it is. But there is one distinction, there is one distinction or one requirement which is positively a requirement for ordinary residents, and that's intention. And you get that from that's the Shah Barnett Council case, and stems from Lord Warrington's opinion in Levine. So it's the need to establish a settled purpose. Now the settled purpose can be there and not be there, as it were. You can have one and then not have one, and that's why it was a useful concept in this case, because it just confirmed the obvious, which is that people's lives change, and so also do their relationships with property, and so this is why you need to test it at any given time.
So what are you actually saying? You need to have a settled what?
This is from if you look at, I think. I'm looking at the wrong.
It's page 30 of the authorities bundle, isn't it? Towards in the last paragraph on page 30 of the authorities bundle.
Are you after Levine or after Ralpho?
I think my Lord Justice Snowden was looking at Levine.
Yes. Yes.
I don't think that. And I think the judgment of it's if at page 40. This is the opinion of Lord Warrington, and it's just the end of the second paragraph. Ordinarily resident. Ordinarily resident also means, so he distinguishes between the two, and that's where you get the sort of the member of parliament. If it has any definite meaning, I should say it means according to the way in which a man's life is usually ordered. And then, if one looks at, it might be useful just. If one looks at Relfa and Vasani, this is a service case. So place of service, usual or last name residence. I'm sorry, it's tab 8. Starts at page 82 of the bundle. And this is a case where it's not a bankruptcy case, obviously, but this is a case where the defendant worked and lived for a substantial part of the year in Nairobi. But he, I think, had I think it was his home and his family were in London. And he regularly, when he could, came and visited the family in London. And then the question then was firstly one of domicile, the possession element of domicile, and the second was whether he had a place of usual residence in London. And then if one picks up the judgment of Lord Justice Etherton at page 87 of the bundle, where he deals, then paragraph 17, he deals with, it's Mr. Sher's judgment. first addressed the defendant's contention he did not reside in England at all. Edgware House was the residence of his wife, but not of him, and the judge rejected that contention, found the quality of the defendant's use was as a home. It was where his immediate and wider family lived, where he returned each year from 2005, where his wife and children settled in the UK, was the place referred to as a home in other proceedings. And then you see you could reside in more than one place at a time, and you could reside in both Kenya and here. The Lord Justice Etherton then refers to Mr. Sher referring to a number of other service cases, and I'll come back to those in a moment. But then turning to the issue, whether the resident was not really his residence but his usual residence. I think usual here is usually taken to be equated with ordinary. Deputy Judge considered danger of over-analysis, and that's the passage where halfway through it may not add very much to the simple word residence, although it serves to emphasise the element of regularity and continuity. And that's the first instance judgment, and then the discussion, Lord Justice Etherton's discussion and rulings are between paragraph 27, page 89 of the bundle, through to paragraph 33 with a conclusion at 34. He starts, whether a defendant's use of a property characterises it as his or her residence. That is to say, the defendant can fairly be described as residing there as a question of fact and degree. If I can just pause there on that particular point. This is, of course, the service cases are in fact place cases, because it's the service provisions, which is place of service, usual or last known residence of proposed defendants. So you're looking at a place and a residence. So this becomes closer to the language we have in this case, rather sort of closer because it's place rather than a characteristic of a particular person. And what you see in the first paragraph is that Lord Justice Etherton effectively, he sort of rather flips the question. He says, do you have a residence? Is this your residence? He then returns that question. Can the defendant fairly be described as residing there? And then he deals with residence separately and says, place where the defendant, it is his home. And then he says, visits every year, stays with family, considerable period of time, obviously in real sense, family home, impossible to send, he doesn't reside there at all. He then separately considers whether it then can then be described as usual residence, and this is the analysis in 29 onwards, and he deals with essentially rejects the submission that it's just simply a numbers game, and that you ignore quality and nature, sort of nature and quality. And the fact that it can fairly be described as family home, and then goes to Levine, ordinary residence. Oh, sorry, this is Viscount Cave, and then Lord Warrington is the one I've referred to, and then Lord Justice Etherton deals with, and this is where you see it's the settled pattern. I think it's probably enough to leave it there for take it if the court just reads through it. So what you'll see is this sort of, for ordinary, it's the search for something something slightly more concrete.
The problem with this case, the problem with that is it's all in the context of usual residence. I mean, this sort of analysis that we did in the last few paragraphs is perhaps much more akin to the ordinary residence, as paragraph 29 sort of draws that direct parallel.
This is but this is then it's consistent with the Mr. Scher's approach, which is to say that you sort of emphasise. It's an emphasis on permanent. Ordinary brings in an emphasis on permanence.
It does, but but in our section, the one we're actually looking at, you've got ordinary resident. Ordinary resident, I think, a person being ordinarily resident.
Yes. Yeah.
And then having a place of residence. And those are, I think you accept those are two different things.
They're two different things, but there is an overlap. So
the overlap is the concept of either resident or residence, depending on what you make of the slight difference. One is looking at where somebody, the person, ordinarily resides. And then the second limb is perhaps, I will put to you, looking more at the property aspect of it, isn't it? I think that's why it might be put. It's not really dealing with the same thing.
It does, but then you have to look at, I mean, rather like those opening, Lord Justice Etherton's opening sentence, because these are also places, these are also place cases. Is this his residence? Forget about usual for the moment. Is this his residence? And the answer is, well, that depends on whether he could be said to reside there. And so that's the connection. That's the connection.
You'd say, is it putting anything? A place of residence is a place where a person can fairly be said to reside.
Yeah. That doesn't mean he has to be there, because residence doesn't necessarily, you're testing it over a period. So whether somebody resides somewhere, they don't have to be there for you to come to the conclusion that they do. Whether they do or do not depends on more than them being there on a particular day or on a particular relevant day. And that's why we've always accepted in this case that you have to look at, that one has to look both at the relevant period but also before it in order to establish whether, by virtue of what had gone before, this could properly be described as could properly satisfy that test.
Is that going to be a convenient moment?
Yes, I've got really just one more. The other authority I was going to take you to...
Would you rather... We could always come back a few minutes late. Would you like to take us to the extra authority now? Would that be convenient?
I think so, because it then probably almost finishes this. It's another service authority. It's Tugashev, which is at page 148. Just a decision of Mrs. Justice Carr, she then was. And this is the case. It's not dissimilar in terms of what in terms of the provisions. This is a case where the question was whether Mr. Orlov was either domiciled in England and Wales or had a usual residence, so place. So it's similar to Vasani. So far as domicile, if I could pick it up at page 179 of the bundle, para 112 of the judgment. You'll see it's 112 just starts with the domicile ground, and if one looks at 113, the 113 and 114. At 113, just towards the end, 113 introduces the relevance of CPR 6.9, so the usual place of usual residence. That's the first half of it. And then the last bit, you'll see Mr. Pymont, for Mr. Orloff, accepted that there was no difference between the meaning of residence under Article 4 of the recast regulation, usual residence, and CPR 69. So residence, that's the requirement that he be resident in the United Kingdom. So that's the first requirement of domicile. And then in relation 114, you'll see, in relation to domicile, Mr. Pymont realistically conceded that on the facts of this case, were Mr. Tugashev to succeed in establishing his residence, substantial connection test for domicile, that's B, 2B, would be satisfied. So all that she is considering, so far as residence is concerned, is residence. And then, so far as residence is concerned, the relevant paragraphs are, it's between 116 and 126, paragraphs 116 to 126 of the judgment. That's page 180 and 185 of the bundles. And there's a single passage where Justice Carr refers to what residence means. And she starts ordinary meaning, 116. She starts with Levine, 117. And you'll see there that we are definitely talking about residence and not usual or ordinary residence. That's the relevance of Levine. And then you go to Lord Justice Saville in Dubai Bank, 118. And this is where Mrs. Justice Bacon extracts a lot of her, obviously a lot of the phrases that she incorporates into her judgment. Settled or usual place of abode, some degree of permanence or continuity. 119 is then Visani and Visani and Relfo. And she there sets out, in fact, both sets. So it's both Lord Justice Etherton's characterisation or description of residence and also ordinary, usual residence, 2829. And then Bestelov, which was a pure domicile question, so residence only. There is there quite a useful summary. Well, she finds it useful, and it is, with respect. I think it's Mr. Bryan sitting as a deputy, as he then was, summary Bestelov, and that is quite helpful. And it's from that that one gets 3 and 4 are familiar. Settled or usual place of abode, quality, nature of defendant's visits, the jurisdiction. 5, whether a defendant's use of a property characterises his or her residence, that is to say, whether defendant can fairly be described as residing there is a question of fact degree, deciding whether a defendant's resident here, and this is important, regard should be had to any settled pattern of the defendant's life in terms of his presence and the reasons for the same. And then 7, you'll see it's quite it's helpful, but it ends up with it's a question of fact or degree. And then she just refers to cases and says all 1, 2, 2, all very helpful, but it all depends on a particular case. And then she picks up at 1, 2, 3. This is the reference to Barnett to Barnett ex parte Shah. And this is context. This is student appeals against local authorities' refusals to grant awards, and this is ordinary residence. And then this is Lord Scarman, and the extracted paragraphs or the cited paragraphs are the ones that deal with both what is meant by ordinarily resident and what the requirements are. And then 124, it's more, again, dealing with Barnett, sorry.
And it says in the middle there, it necessarily means that a person has at any one time only one ordinary residence. Is that right? I'm assuming it said House of Lords, it must be right.
Yes, I was going to say. Wouldn't like to say it, but
you'd say you can only have one ordinarily. You can only be ordinarily resident in one place in the first limb of our section.
yes.
But you can have more than one place of residence.
Yeah.
Is that right?
Yes.
So the jurisdiction for bankruptcy purposes is either where you are ordinarily resident and there'll only be one place. It's a higher requirement. But place of residence, you can have more than one. So, in a sense, it is a broader.
The second is broader, and obviously it's it's broader. Curiously, it's broader and narrower. It's broader because it's residence, and not ordinary residence. It's narrower because you're looking at place rather than ordinarily resident. It refers to the jurisdiction. The jurisdiction in its widest sense. The widest sense, you just need to find that ordinary residence in England and Wales, say. But can I just finish this just with the 125? And so, having gone to Barnett, you'll then see this submission that the search for residence thus looks for an abode that's part of the individual's regular order of life for the time being for a settled purpose, whether a short or long duration, doesn't matter what that settled purpose is, not necessarily a family home, existence may demonstrate settled purpose. I agree in broad terms with these observations. So it's not, Lady Ms. Justice Carr doesn't treat what is derived from Barnett as a test, but more like a factor. And then you can see that whilst Shah is another helpful illustration of the ordinary test explored and applied on its facts, I do not consider that Shah materially, for present purposes, adds or detracts from the principles already identified above.
So
that is very much a useful moment. I'm sorry I've kept the court sitting for longer.
So we come back at 2:05.
I will speed up. I think the material is there, and I'm conscious that I have very little time.
Court rise.